but in the text. Fantastic. So good evening, everyone, and thank you for taking time tonight to join our session. I'm Ken Wingrove, and I lead the wealth management team at Interior Savings Credit Union. And I've brought our resident expert on all things estate planning, insurance, and business succession planning, Doug McMechan, whom you'll have a chance to meet in a few minutes. But before we get started, we'd just like to respectively acknowledge that UBC Okanagan is situated on the traditional, ancestral, unceded territory of the Sayux Okanagan Nation. I would also like to acknowledge that you are joining us today from many other places, near and far, and we want to acknowledge the traditional owners and caretakers of those lands as well. So also, if you're not familiar, this is the 10th annual Okanagan Embrace Aging Month. And so thank you for joining us tonight. Embrace Aging is co-hosted by the Institute for Healthy Living and Chronic Disease Prevention and at UBC Okanagan, as well as a partnership with Interior Health and Interior Savings Credit Union. And Interior Savings Credit Union is a sponsor for this event. And if you don't know, Embrace Aging Month was started about 10 years ago, really to celebrate and raise awareness around positive aging, how to do it well. We organize a large number of events throughout the month. So we're coming to a close, but there might be still a few more that you can join. And these sessions really are designed for everyone, young, old alike, and really a focus on a wide range of topics that can just inspire us to age positively. So with that, we'll get started. So really for today, I think there might be a poll question coming in, so we'll give you a moment to answer that. Our goal today is that Doug and I, we're going to try and keep this conversational. We're going to try and keep the language easy to understand. The goal is that you maybe get a better sense of what areas you could possibly pay attention to leave a less messy legacy for yourself. And so we hope you find this helpful. So just give it a few moments for your questions coming in. Fantastic. So maybe a wide range of people, some feeling organized, some feeling a little less organized. So we're going to go through a top 10 list. We're going to try and keep it simple. A lot of it may not be surprising, but hopefully you'll find a few areas where maybe you do need to take a step back and look. So I think first off, a will is certainly a foundation of your estate plan. And if you don't have one, you should have one. But really, it's probably the first thing that comes to mind when you think of estate planning. A will is a legal document, and really what it does is it lets the courts know what to do with your estate. And so I guess if you get the first thing out of it is if you don't have one, that's probably the first step. But if you're like 95% of Canadians, we don't update them as often as we should. So that would maybe be the next step. We're going to talk a little bit about why. So before we do, you might be asking, well, what's the risk of dying without a will? Well, really, the risk of dying without a will is a few things. One, it's going to be more costly and more time consuming to deal with your estate. But also for your loved ones, they're going to possibly see the situation where your estate may be distributed in a manner based on the estate rules in the province, but not exactly maybe the way you had wished. And so the key here is that by having a will, you're going to make sure that your estate is going to be distributed in the manner that you see fit based on your wishes. So aside from documenting a will, the other thing that you do in a will is you appoint an executor. And essentially, if you don't already know what that does, that basically means that after you've passed away, this person's going to have a role of doing things like taking an inventory of what are the assets of the estate, who are the beneficiaries of the estate, and where are their addresses. There's going to be some tax filings and some forms, and it's a lot of work.
And Ken, I agree. I think people work very hard throughout their lives, raising families, building a business, working hard throughout their career. And we take a lot of time planning for going on a vacation, but not a lot of people take a lot of time to plan for their will. So, you work hard for what you have and care a lot about the people who are in your family, in your world. So yeah, it's just an important thing to take that time.
Yeah, absolutely. Thanks, Doug.
Yeah.
And so sometimes we get some of the terms mixed, but the second thing would be the power of attorney. The key difference between the power of attorney and the executor is that the power of attorney is someone that you designate that would look out for your best interests and help you handle your affairs when you're maybe no longer able to while you're alive. And then after you pass away, then that would cease to be in force. And that's when the executor would then fulfill their role. So those would be the two separate things there. And so, when you think about a power of attorney, they have a broad range of responsibilities. It's a tough job. And I think, again, the key thing is making sure that these people know that they're going to be helping you. So a power of attorney or an executor, you should have these conversations with them. Obviously, hopefully make sure they're on side, make sure they're feeling comfortable and able to fulfill their role. And if not, you might have to consider someone else. But again, I think these are the two fundamental things that start the foundation of estate planning. We're going to go into a few more details around there. So I'm going to pass it over to Doug to talk about family meetings.
All right. This is something I think can add a lot of value for a person as they're planning their estate and for their family members. Everybody's family and financial dynamics are very different. So the idea of having a family meeting to talk about your estate, your will, how things are managed, for some families is easy. Maybe they talk regularly, and some families it's not as easy. So, but I think having this family meeting and discussion provides a lot of transparency, helps to prevent mistrust, and the discussions behind the scenes as everybody's trying to figure out what the plan is. So one thing that might help as people are planning and wanting to have a family meeting could be if you had an agenda to start before the meeting, because it helps to keep everybody on track, where you can talk about your will, where your will is, who the lawyer is, you can talk about what it says, you can talk about the assets that you have and what's going to happen with them. You can choose the path you go down in the discussion, but you would also want to talk about who your executor is, perhaps who the primary executor is, who a backup might be. You want to also talk about your power of attorney. This would be an ideal time to talk about the power of attorney. And when you name power of attorneys, part of that process is there's an actual power of attorney document that each person who's being appointed has to sign off on that document to accept that and understand. In addition to that, what this does is it helps to clarify your intention and the reasons for the roles. Why did you choose your child or sibling or a friend to be the power of attorney, to be the executor for your will? You can also talk about what your care wishes are in this family meeting. Like most people I find want to stay in their home as long as they can. That if they can have care come into their home to help them so they can stay where they're comfortable, then that's most important to them. So outlining, where they would like to be, what type of, whether they want to stay in the city that they're in, whether they want to be closer to their children at that point in time, because the challenge is, what if things change and you don't have the ability to make changes in your wishes? So talking in a family meeting is a good open discussion, because one, it clarifies for family members what you intend, and it might raise some good questions from the other side, things that you want to consider and maybe make some adjustments to your plans. Thanks, Ken.
Yeah, it's a great point, Doug. In your experience, how often or how soon do you see clients bringing their family members in on some of the discussions around estate planning, Doug? Is that something that you can help get them talking about these kind of difficult discussion points?
Yeah, it can be something can help people to think about, and if they feel it's going to be more of a challenge, I guess they'll have to decide for themselves. But that's where, again, I think if you want to go ahead and have a family meeting, you feel it's not necessarily easy, having an agenda and sharing that with people, it formalizes things a bit, but at the same time, it kind of tells everybody what you want to talk about. And I think that helps to lead the way.
Right.
So next point, a letter of intentions. I think the family meeting, this kind of, leads into it. The letter of intentions is something that I would think I would write, and I would leave it with my will. It's not a legal document per se, but I would leave it with my papers, that for at the time that I pass away, because in there I can say things in my own words. It's a chance for me to have my voice heard after I'm not there, provide a degree of clarity for family members. I can tell them about funeral information, financial information, like in there I can provide a detailed listing of my credit cards, bank accounts, my insurance contract details, who my advisors are, digital accounts, like if I have, Facebook or something like that, information on my passwords. I can also outline some personal items that I have. If I have a pool table or a favorite canoe or a special ring that I or my spouse wants to go to someone specifically, that might be a good place to either state that, or perhaps to state why I want my fishing boat to go to a friend, because maybe we've fished together for many years and it's very important. So those are things to think about. Aside from that, you can also provide information about care for if there's a special needs family member, or if you have a pet or several pets, you might want to provide details on how you would like them to be cared for. And see, this letter of intention, it's written from you. And I think it could be a very interesting way to have a final chance when everybody is listening to say something to your family member in your family members in your own words. You can talk about special times in your life with them, how much you enjoyed those special times, the trips that you had. Maybe it's the times that you went to the cottage. For me, it's time when I went to the island with my family. Those are all special times. And I think it just gives you a chance to talk about some of those things that are important to you. And I think it could be very meaningful to the family members at that time.
That's interesting. So, Doug, from your perspective, the letter of intentions is sort of the backstory to how you got to capturing your wishes in the will, essentially?
Yes, yeah, that's a good description. It just provides more detail, because the will is really a fact-based document, and this is the backstory as to, why did I leave specific items to somebody and not somebody else, or what my intentions are, or what my thinking is, because the will doesn't really explain how you feel. And this is where you could say, this is why I feel like this is important, besides saying some of your own thoughts and words. So yeah, thanks again. That's good.
Yeah, it's a great point. Throw a few comics, a little tongue in cheek, it's probably easy for someone to say, well, just have a family meeting, just write a letter of intentions. We know that this can be challenging, and, every family has its own dynamics and dysfunction and complexities. And so we know it's easier said than done. I think, though, what we've learned in helping people along the way is that talking transparently, sharing these things sooner than later can avoid these surprises that lead to a lot of hurt, where there tends to be some bitterness or some questioning around the why. If the why and the conversation around your wishes can be communicated up front, that's going to go a long way. I think about sometimes when a spouse says they don't want a surprise birthday party for their 50th birthday, sometimes you have to take them at their word. You may not want to take a chance with how are they really going to react. And the same is probably true of estate planning. And, I can think of a few examples. Sometimes without thinking, there could be surprises where possibly you designate the beneficiary for an RSP or a RIF that ends up being significantly larger than some other assets. Oftentimes, another surprise that can lead to some hurt feelings is not considering the tax consequences of how maybe insurance proceeds might be dealt with versus, say, a property that's being left to beneficiaries, or as well as some financial assets. And so they're really, those are things that you really do want to think through. This webinar is not designed to, take the place of legal advice and seeking out tax advice. This is really just to say, these are some areas that you don't want to leave to chance, because again, these surprises when you're maybe grieving the loss of a family member, if you don't have the transparent information up front, you might be questioning the relationship or the why those decisions got made. And that can make things even harder. And again, the goal is a less messy legacy. So
I agree fully, Ken. I've seen, I can think in the past where a lady I knew, her and her three sisters were all very close, and their father had passed away previously. And I know that at the time that mom passed away, there was some difficulties in terms of how the three sisters got along at that time. And I think a lot of it was because of their expectations of what was going to happen within the estate, how things would be handled and distributed. And the outcome was, was different than they expected. So if they had had that meeting, it might have saved the relationship between the three of them who were very close before mom passed, and, might have made things easier at the time of settling the estate. So having the discussions isn't always easy, but I think it can be very important. And it's you'd probably prefer to be there so you can help to explain, how you feel and the decisions you made.
Absolutely. Thanks, Doug.
Yeah.
So then moving to health decisions, a power of attorney does have a broad range of authority that can apply to health decisions. That being said, it might be worth, seeking out advice around, do you want to actually delegate the role of health decisions specifically? You can do that through a representation agreement, where you'd appoint someone to be more in that role to help with the health decisions, with wellness decisions. That could even be, physiotherapy on a regular basis, or getting your nails done, some of those things. But it also does apply to the more serious health decisions as well, too. I think that for the clients that we see, there is enough of a burden around being a power of attorney. You want to sometimes see who's best fit to help you take care of your needs. And in some cases, splitting up those responsibilities can be helpful. This works particularly well where maybe geography is an issue, where there's one sibling that happens to be a lot closer to you physically, where maybe they take you to appointments, maybe they get groceries, and so some of those things might be a natural fit to health decisions, whereas maybe another person might be more equipped to do the financial side of things, the online banking, taking care of some of those decisions. And so this gives an opportunity to do that. Doug, pertaining to this area, how would you see, based on your experience, people lightening the burden for those in regard to health decisions?
Well, I think by having that, say, representation agreement or similar in place, what it's doing is you're giving them some direction as to what level of care you want if your health changes significantly and then you're not able to relay it to them at that time. They still have to, my understanding is they still have to, take consideration at that time for what the events are, what's happening, what your level of health is at that point in time. But by giving some directive, I think it helps to make the decision a lot easier. It gives them something to look to for direction in terms of what you want, so that the burden just isn't on them making that healthcare decision for you. I would rather be clear, because some people, they would rather go to the last degree of opportunity to try to maintain health or to maintain their lifespan. But some people would choose, if things aren't as they would be comfortable, they may choose to make a decision that at some point in time they would rather just be more comfortable and not be a burden to the family. So there's lots of discussion going on around that these days, certainly. And I think that those are all very important discussions for people to have amongst their family, like certainly with the close, like with your spouse and others, to let them know what your wishes are, and also to talk to the legal person who can put those plans and directives in place. Because if you don't have the proper directives in place, then things may not go as you intend. So that is very important with each part of the estate planning here.
Absolutely. Thanks, Doug. And I mean, this is a particularly sensitive topic, because everybody in the family typically has an opinion, a feeling, or a thought around this. The key here is that going back to that family meeting or letter of intentions, if that can be the guide where everybody in the family had heard and understand what your wishes are when your health gets to a certain point, then that's going to be helpful. What I've seen over the years also is that there may be more discussions around situations as they progress more slowly. But oftentimes it can be difficult when you're looking at a situation that comes up, say, in terms of an accident or a diagnosis that works through quite quickly. When family members are rushed and maybe they don't know the wishes, that's a lot of stress just navigating this. So again, trying to get these decisions organized and in place beforehand is going to help you along the way.
Yeah, definitely.
So life insurance, I can't think of anything more exciting than what we've already talked about in life insurance. So Doug, over to you. I think you know a thing or two about this area.
Yes, and I know I always laugh because I think when people wake up in the morning is the first thing that they're excited about and thinking about, today I'm going to go out and buy some life insurance. I'm not sure that many people get excited by that, but no different than a will or power of attorney. It is a very important part of your planning, and there's really different stages in people's lives. There's the stage when, say, you're starting out and you have a mortgage and you have a family, and your goals are really to protect your family, because See, life insurance, people think of life insurance and they think, well, do I need it? Do I not? But life insurance is really about providing tax-free money at the time when somebody passes away so that there is liquidity to, in a family situation, there's money so that you can pay final expenses, pay off the mortgage, other loans, and replace income. Basically, the premise there, so your family can stay in their home, stay in the same neighborhood, they can maintain their lifestyle and continue to do the activities they've, gotten used to doing. And we know it's the costs of groceries, everything are going up so much. It's very important to account for that. And then the other piece I would say for insurance is not just where there's kind of those years where you need insurance because you have those obligations. And then another stage really is you've built some assets like your RSPs, maybe you've got investments, like you have shares that are growing in value, you have a revenue property, a place at Big White, a place at the lake, something like that, or maybe you have shares in a business. And what happens is as the value in those assets grow, you have tax. As your RSPs grow, well, the value of your RSPs, probably about 50% of the value of your RSPs is going to go to taxes at the time you pass away. There's tax on the capital gains for the growth and the value of your assets. So it's important to sit down with an advisor to understand what the implications are for you, for your estate. And that's where life insurance can be valuable after the time that you built your assets, perhaps getting closer to your retirement years. Life insurance can play a very important role there too, because it can help to ensure that your estate value doesn't shrink significantly when you pass because of those taxes. It can help to equalize the value of your estate, because maybe it's important that if you had a child that lives here and uses the family cottage a lot, and then you have another child who lives 2 provinces away and doesn't. So maybe it's very important that the child here has the family cottage, and life insurance can be a very good way to equalize the value of those shares, of the share within your estate. So, and life insurance is also very good for like business planning too. Within a corporation, you could have 2 owners. You want to set up a shareholder agreement or buy-sell agreement. So if one of the owners passes away, it provides tax-free money immediately so that the deceased shareholder's family can continue in their life, and that the remaining shareholder can fully own the business and get on and continue the business in the manner that they had planned. Another area life insurance can be very valuable is charitable giving. We think of here, you hear a lot about, say, that the Kelowna General Hospital Foundation raising money. All the charities are raising money on an ongoing basis, and a big part of their charitable giving is using life insurance because it's tax-free money that they can use at the time that donor has named them as a beneficiary. So life insurance has many practical applications to help people. It can also, in where say you've done really well, you've contributed as much as you wanted to your RSPs, you're putting as much as you want to into your tax-free savings. It's another way that people can not just protect the future growth of the assets and have money to pay the taxes in their estate, but it's a way that they can tax shelter the growth of money within their life insurance. And there's ways to access that cash value along the way to help supplement income, or to provide an opportunity fund for things that might come up in the future that you want to take advantage of. So anyway,
yeah,
I've talked lots on that, but there's a lot more ideas and opportunities than a lot of people realize for how you can use life insurance to your advantage.
I think the one other thing I'd add is that, when someone passes away, there's a lot of immediate needs, immediate costs and
Yes.
things to take care of. And life insurance is one of those things that doesn't take as long to process as perhaps some of the other things when we talk about dealing with property and things. So it is a nice thing to be able to have in that way. And
Yeah.
certainly, like Doug mentions, equalizing the estate as we see other assets maybe growing. Life insurance is a great way to do that.
Yeah, tax-free money that's paid quickly at the time it's needed. That's so.
Absolutely.
So
Great questions going on.
Yeah.
So please, again, keep submitting them and we'll try and tackle as many as we can towards the end.
So what is the responsibility when we're thinking, is it an honor or a chore to be an executor or a power of attorney? Well, I mean, it can be a great honor, but it is something that is very time consuming. It often takes a lot more work than people expect. And there can be a lot of risk involved as well, because it comes with some liability, because you're managing and looking after another person's finances, and it's important not just to that person you're helping, but to the other people around them. Their other family members are, watching, looking to see how that's managed. So is it an honor? Well, it can be. I think when I was younger, I always thought it was an honor. As you realize more what is involved, you realize it is a chore. It's a very important chore. What does it entail? Well, Ken talked a lot earlier about what it entails to be an executor or a power of attorney. Basically, it's on the financial side, knowing what the person has and knowing what the person needs for one, when you're the power of attorney, for their care, when you're executor, what they need in terms of their wishes from their will and how their estate is to be handled. Is it reasonable to be compensated for this? Yes. Executors are typically paid somewhere between about 2% to 5% of the estate for their work. And I think that makes sense. The final percentage amount usually changes and depends on both the province that a person's situated in when they pass away, and also the specific circumstances in the estate, the size of the estate, the amount of work and care and responsibility that are involved. So it is reasonable, but there is a range. If a person doesn't want to deal with it entirely themselves, you can seek some help. On the power of attorney side in BC, they basically say that a power of attorney is not to be compensated for acting as an attorney in BC unless the enduring power of attorney document expressly states and authorizes the compensation for that power of attorney. And then it must also set out the rate and the amount that a person is to be compensated for. An attorney can be reimbursed and should be reimbursed from the adult's property for reasonable expenses that are properly incurred in acting as the adult's attorney. But I think, just to restate, I think in either of these roles, executor or power of attorney, what is very important is when you're taking on this responsibility is to document the decisions that you make, document the expenditures that you make, because have the expectation that people will ask about how the money was used, whether it's income to care for somebody or it's spending money to settle a person's estate. So that would be a key thing I would recommend.
Yeah, absolutely. And maybe the one other thing I'd add is that, when you're designating someone as a power of attorney, or especially an executor, they're in a position where if they have siblings and other family members, their eyes are going to be on them and paying attention to are they doing things, and that's where the opinions, again, without the knowledge of the backstory, can be tough. So this is a hard role because, again, anything that doesn't seem fair, again, there could be some subjectivity or judgment on the executor or power of attorney in terms of, are they really following through on the wishes. So it's a tough role. There may be a bit of an honor to it, but I would say for anybody who's had to do this, it's a big job, and we often do see people coming to get help for this.
Yeah. So next, lighten the load. What things can you do? Just in following what you're saying, Ken, should your executor be a spouse or sibling? Well, it certainly could. I would say, or a child. Most often, I think in wills, people appoint their spouse or sibling or children. The considerations would be, what is their age? What is their health? Are they capable? And, very important part is, are they willing and committed to do the work? So it's important to talk to them about this, the fact that you would like somebody to be your executor, to be your power of attorney. And I think it probably would be good to take some time yourself as you're doing that to look yourself at what are the responsibilities as an executor and power of attorney, and to sit down with that person and go through what some of those responsibilities are. Most often, I think people, they say, would you like to be my power of attorney? And the person might agree to it and they just sign the document, probably not fully knowing what all is involved. So I think, as I think through things, I think that would be a good idea. And it's also important to go back from time to time to talk to your executor again. Maybe it's every 2 years or every 5 years, to make sure that they are still willing to do that job. Because maybe something has changed in their life and maybe they don't want to take on that responsibility. So if you appoint somebody and they feel they can't do that full role, say as the executor, one thing you can do is you can consider a trust company, a corporate executor, or a lawyer who may work as a co-executor with you. They're going to charge some fee to do that, but you might find as you get into that role that it would be of value to you, especially if there are some ropes and hurdles along the way, something that you're not expecting. So that's an option to consider. And a lot of those companies will work with you. The next part, pre-planned or prepaid funerals. Again, I think just as we've been saying all along, Ken, the idea of a letter of intent, planning as much as you can to make things easier for people at a difficult time. I think if you prepare your funeral wishes in advance, because a lot of times the funeral or celebration of life is carried out, not too long after a person passes away. It's a stressful time. People are tired. There's a lot going on. People are very emotional. So I do think, whatever your plan is, whether you want to have a funeral at a funeral home, whether you want to be cremated or buried, or maybe you just want to have a big family dinner and gathering just as a celebration of life. It's your opportunity in advance to say what your wishes are. So if you don't state it for this or other things, then people will decide for you and what they think that you might want. And that may be correct or it might be different. But yeah, so you have this opportunity then to make a plan, take out some of the guesswork, reduce some of the potential disagreements, and really have things, finalize things more based on how you want it to be. So
well said, Doug.
thank you.
So in the theme of review, we've got some great questions, so we'll try and burn through the last few points here so we can tackle as many questions. Beneficiary review, one of the themes we've talked about is there's really no one and done. If the last 3 years have shown us anything, circumstances can change quickly. That might be our children experiencing marital breakdown, and maybe that affects how we've appointed roles. So we need to review things, and beneficiaries would be another thing. When we look at, tax-free savings accounts, retirement savings accounts, RIFs, RSPs, those kinds of things. Those aren't actually going through your estate. They're just going straight to the beneficiaries. But the issue is sometimes we can have, say, if you're leaving your RSPs to 3 children, maybe as a contingent beneficiary, if one of those children passes away or predeceases you, then what a lot of people don't know is then that would change the allocation from a third to possibly 50-50. And is that what you intended? Or, would you have wanted your grandchildren to have been taken care of or addressed in that? So it does take some thought around that. Again, no amount of review and updating can take care of everything. In insurance policies, pension plans, those are other things where I think Doug's going to talk to, where do you find all these documents? Where do you store them? So, some people have a hard enough time figuring out where their insurance statement is, let alone, who their beneficiaries are. But I would say that ongoing review, especially as you're getting older, once every 1 or 2 years really makes sense. And connect with your advisor. When family changes happen, they can help kind of guide you with where to look. But really, this is the ongoing review. I think, the thing as we get to 9 and 10, do things while you have capacity. We've talked a lot can change. What's the risk of if you don't? I think Doug's got a story here coming up as it relates to backup plan and how things can shift a little. But the thing is that you have to have mental capacity to write a will, to designate a power of attorney, an executor, as well as changing beneficiaries and those types of things. And so what we really know is that we don't know how much time we have. We often also don't know how fast our memory, I see my memory coming and going a lot of days as it is, but it's really one of those things where you want to make sure those changes are made while you have the chance to do it, so that again your wishes can be carried out in the manner with which you intended. So I'll pass it over to Doug to talk a little bit about how can you prevent against some of these things with backup plans. Doug.
Yeah, thank you, Ken. There's a lot of information, a lot of things to consider, that's for sure. But the unexpected does happen, as Ken said. So here's an example of a story, because it's important to have a backup person, for your power of attorney, for your executor, those types of things. An example of a situation that I've worked with where the husband had his spouse as his power of attorney. He had a friend as a backup. And then what happened was his health changed so that he couldn't have mental capacity to make decisions any longer. Then his wife became the power of attorney and looked after things for quite a few years. But unfortunately, she got ill and she passed away and predeceased him. So at that point, they reached out to his friend that he had named as the backup power of attorney, because he has children, but they're not in the same province as him, and he wasn't as close. So he named his spouse as the power of attorney and his friend as the backup. But his friend at that time either couldn't or wouldn't go ahead to act as power of attorney. So what it meant is that the daughter in this situation had to apply to the courts, had to enlist a lawyer in BC, and had to apply to the courts for what's called comiteeship. And comiteeship is the same thing as power of attorney, but what it means is you work with a lawyer, you go to the court, apply to the courts for comiteeship, you pay a fee. So it costs several $1,000s. It takes several months, probably in the ballpark 6 months to have that happen. So in this situation, well, it was just a lot of work before it was able to act, to look after the investments, to make financial decisions. And that's a pretty big gap of time if you need to have access to cash, to more income or anything like that. And then a similar type of event can happen, obviously, with an executor. It's important to have those backup plans. Even when you have a backup plan, sometimes things don't happen exactly as you would like, Ken. So next thing, where to keep those important documents. Well, first of all, I think in addition to having your will, your power of attorney, you want to create a list of those important things. And that's where that, the letter of intentions, having an estate, say, inventory list of other items. And I think you want to list your credit cards, bank accounts, your life insurance, home, vehicle insurance, your investment accounts. Have everything somewhere in one place and probably make 2 copies of it so that if something happens, but you can keep this in, if you had a safety deposit box, you might be able to keep it there. If you have a fireproof box or a fireproof safe at home, that's a place you can keep it. Or, well, an alternative, probably a good alternative as well, is that have a copy at home and have a trusted friend or advisor that you can keep a second copy with in case something unexpected happens.
Yeah, I know, it's difficult to put that together, but
Yes.
that's super important. I know I've put together a bit of a binder and have to update things regularly. And again, having those backups, things can happen. We know, fires, floods, alike, there's lots of things. So it could be a combination of storing online, electronically, or physical copies, but it is good to have those.
Or forgetfulness, as you had mentioned earlier, too, can happen. And that's why if you have somebody else in a backup plan where it is, then that helps too. Sorry, Kevin.
Absolutely. No, you're right. So we're nearing the end, Doug. Any last kind of things to reflect on before tackling some questions?
Yeah, I think, well, if you've completed most of the details we've discussed, you're doing great. Your estate is obviously now a lot more organized than I would say than most people. You do need a legal professional to set up the documents such as a will and power of attorney. And part of their role is going to be to ensure that your wishes are met as intended in setting up those documents. Again, the will, the power of attorney, the health care directive or representation agreement. Those are all so important. And you want to talk with your financial advisor so that they know what your intentions and goals are, so that your beneficiaries are in line with your goals too. So
thanks, Doug.
Yeah.
Great information. So we've had a lot of great things coming in. I really appreciate the engagement. We've got our email address too, if you've got questions privately that you want some help with. But I'm just going to pull up the webinar chat here and we'll get into some of these questions. Okay, so maybe we'll start with one of the first ones. What do you think of Willful for preparing wills? Doug, I'll give that one to you. I think that's an online platform service, right?
I'm not specifically familiar with that, but I know there are online platforms where you can go to set up a will. I'm sure some of them can work to meet a person's needs quite well. I guess the key thing is if there are any specific details, it's hard to know for sure if you've met all those. And I'm not being a proponent for not doing them, but I think myself, I'd be more comfortable because if it costs me $1,000 to do a will myself with a legal professional who can review it and ensure that all the details are met, I'd be more inclined to do that because they can ask the questions and the considerations. But a lot of people do the online wills, and it might work for you. Do you have any thoughts, Ken, on that yourself?
Probably it depends on the complexity of your situation and your family dynamics. But you know, I do think that in many cases you might want to consult with a lawyer to get specific advice around how to tackle or approach certain things.
Yes. Yeah. The more complex, the more legal help you would need. And I would like to think the legal help that you receive is going to help you to realize where some of the complexities may lie that a person doesn't realize as well.
Yeah, absolutely. I mean, the cost is a factor, but
certainly.
doing it right and making sure that it allows things to happen the way you want is also important. But I think it's pretty interesting. I mean, it's nice that there are some electronic options out there for people now.
Yes.
Okay, second question. Is there a problem if your executor is out of province?
I believe it. Well, one, I think it's a lot easier for them to deal with things if they are in the province, and I think it's generally recommended to have an executor in the province. I think you should ask the lawyer or legal expert on that specifically, so that they can address whether your executor is out of province and what type of issues you need to address there. Yeah,
I would agree. You know, and again, you know, a lawyer would be able to help you with that. I do know that if your executor is in the United States, that's probably something that you're going to want to look into before doing that, just because of the IRS and the tax implications of that. But I think it's more of a logistics thing from province to province for sure, just because there's going to be reasons you need to travel and to take care of different things. And so again, depending on the flexibility of that person to be able to go between it, just geographically might be a little more challenging. Okay, fantastic. Is there any benefit for someone living alone with no dependents to have life insurance? What do you think, Doug?
I guess the benefit for someone living alone with no dependents, I guess the key thing and considerations would be how much are the funds that you have aside from that? Like, do you have investments and assets set aside that can be accessed quite easily to cover final expenses and things like that? Is there money that can be there? Because say if you have a home and you have a mortgage, well, the mortgage still has to be paid ongoing, as do the taxes and other expenses, until that home is sold or whatever happens to it. And say if somebody didn't have a will and they owned a home, well, it's going to take quite a while for everything to be settled. The value of life insurance for someone who's living alone with no dependents would be probably some money to cover final expenses and some liquidity. Without knowing a person's overall situation, it's hard to say for sure. Do you need it? Do you not? But there can be some benefit to have some life insurance.
Yeah, for sure. Again, depend on, you know, do they own a business? There might be some implications there. You know, and certainly there may be less of a need, but it might still be something worth considering. One of the other questions we see here is, should I provide my bank a copy of my enduring power of attorney?
Yes, you should provide your bank a copy of an enduring power of attorney, but I would say it wouldn't be necessary to provide them, I don't think, until the time that typically, I think what happens is what we see is at the time when a person is either incapable of making decisions or their capacity is diminishing, that they choose at that time to have the power of attorney, provide that power of attorney to either the financial institution, to their financial advisor. That's typically what I have seen.
Yeah, absolutely. But at some point, for sure,
Yes.
when the time is right, you'll need to do that. You know, and there'd be an aspect of doing that on the day-to-day banking side, as well as potentially some investments as well too, when that happens. Okay, fantastic. Another question, beneficiary, is there quick access to money? Are these funds taxed?
So if it's life insurance and the beneficiary is named, the money is paid out generally very quickly. There's just a couple of reports and information the insurance company needs. The money is tax-free and then is paid out tax-free. If it is, if it's an investment where you have beneficiaries named, the money is paid out, yeah, very quickly. Typically, I would say, unless there's some reason that there's an issue within an estate, say, that might challenge or hold things up. Typically, I would say on investments that I work with where beneficiaries are named, it's usually within about 3 weeks of the time when the investment company has all the forms that the beneficiaries have funds. So, and taxation, well, if it's money in an RSP or a RIF or money from a pension plan, yes, it's fully taxed. If it's money that's in investment funds or mutual funds, the tax would be on the capital gains or the growth in value. If it's money in term deposits, then it would be the interest earned to date in that year. That would be taxable. And that'd be taxable in the final tax return for the estate.
Yeah, and I mean, it is, there of course are some spousal rollovers where there wouldn't be tax for the spouse. But yeah, for other beneficiaries that are not a spouse, there could be some tax consequences. And again, just recommend speaking with your accountant to get a sense of what would be the impact on that. There's usually that's taxed impact on the estate when you file the tax returns and those types of things. But that is worth consulting and getting some advice on.
Yeah, those are good points, Ken. Basically, when somebody passes away, if I pass away, the final tax return is done in my estate, and the taxes are paid by my estate. It's not paid, the tax is not paid by the beneficiaries, it's paid by my estate when I pass away. And if I have a spouse, my assets can roll to my spouse. My spouse wouldn't pay taxes, but if I had children that they're going to, or anybody else, that's when the taxes have to be paid, whether it's a non-registered investments or business shares or RSPs. That's
right on.
Yeah.
Yeah, we're seeing some people saying hadn't thought of the letter of intentions. I'm sure there's a lot of family meetings going to be scheduled after the session tonight, which is fantastic. So seeing a question here, what is probate and how long does it take? Are there ways that you can reduce the costs?
So, well, probate is the process where the provincial government basically you provide the will to the government and you apply to the courts for them to review the will, and then what they're doing is they're saying that yes, the will is valid, or no, the will is not valid. And there's a fee that province charges. It's about 1.4% in BC of the value of the estate that is probated. How long does it take? I guess it depends on the work of the executor at that point in time. They gather everything up and then they apply for probate. Estates to be settled 6 months, 12 months. It really depends on the complexity of the estate. In BC, people can choose to challenge a will. We have the Wills Variation Act that may come into play. How can you reduce the costs for probate? Probably the best way that you could do that. One, I suppose you can give some of your assets away, but it's important not to give away too much. You need to make sure there's funds to look after yourself, and hard to ask for the money back once you've given it away. But there are some investments where you can name beneficiaries, so that can be a consideration. Naming beneficiaries is a way, because that money then goes outside of the estate. It generally should avoid probate fees and is paid to the beneficiaries quicker than the settlement of an estate and probate.
Yeah, absolutely. I mean, the only other thing I would add, and for those that are maybe wondering, what types of assets are probatable, in many cases, like real estate, real property, and investments that aren't, sort of registered retirement savings or tax-free savings accounts, those types of things, then if they don't fit that, if it's real property, real estate, investments outside of RSPs or TFSAs, then those would be probated, unless, like Doug said, with seg funds or designated beneficiaries, there might be some angles. I would say that in terms of reducing the costs, it's not that expensive, even still. I mean, it's about 1.4%. Again, it depends on the size of the estate that you're dealing with. There may be options. We didn't tackle options of setting up trusts or seg funds for this. There are situations, and if you have one of those, we'd be happy to chat. But I would say 1.4% to validate that the will is the last will and that it's appropriate, and to make sure that your assets are going to the right place. It's not the most expensive thing to do. Again, when, like Doug says, when you start making accounts joint or gifting money, and again, it depends on your family situation. I'm not going to say that it's not right. But again, it's hard to reverse, and with the cost of retirement and living longer and those kinds of things, that's a consideration.
Yeah, good points.
Still got a few more coming in. Okay. Is there any way to transfer real property to beneficiaries outside of the state upon death? Example, using a deed of sale transfer. That sounds complicated. Over to you, Doug.
Thanks, Ken. I think there are ways to transfer property to beneficiaries. I'm trying to think, can you do it outside of the estate? I don't know if you could do it outside of the estate. I guess it depends how the asset is owned at that time. It can pass, real property can transfer from one spouse to another. Real property, you can have somebody who's joint on a property or joint on an account, and then it can pass to them potentially outside of the estate. It just depends on the other factors within a person's estate, but there's considerations about having people joint as well, because there are pitfalls, I guess I would say, potential pitfalls on having somebody joint. As far as using it, I don't know about using a deed of sale or transfer. I'm not familiar with that. I don't think you can transfer property to someone other than your spouse, and for the purpose of avoiding taxation. That's the point in time when it has to be paid, whether your RSPs or capital gains on other assets.
Maybe the only other thing, I think it maybe wasn't so much about taxation, but more about avoiding probate. Upon death, that might be more of a thing to speak with a real estate expert, a lawyer on that. Sometimes we do see people trying to transfer title of properties before they pass away. Again, that's something you'd want to make sure you were comfortable doing at that point in time. There'd of course be property transfer tax, which provincial government would love to see. And then of course the other thing though is that does open up risk with regards to who you're transferring to, and depending on the family dynamics of the people that are inheriting or you're transferring property to, if their marriage is in a good place or not. There are a lot of family complexities, but that can be done before. if your life expectancy is 2 to 3 months, would it be a good idea to give money away rather than leaving it to after your death?
Yeah, an interesting question for sure. And I would say, as long as, if I was in that situation, as long as my finances and everything was okay to be looked after up until the time I'd pass away, I think it would be a reasonable consideration to give money away prior to that time. I guess it would just depend on, the certainty of that life expectancy being only a few months, and what the dynamics are in the family, and what your will and what your estate says at that time too. Again, because in BC people can challenge things, and people can challenge things really at any time. The only potential issue might be if you give property to somebody before you pass away, or be it money or otherwise, it could be open to challenge at some point in time. So,
Yeah,
but I do think that would be a reasonable consideration, though.
Yeah, absolutely.
Yeah.
Some great questions, and certainly there's a lot of different situations. We hope this was light enough. I know it's maybe a heavy topic, talking about death and just the dread of having family conversations. Thanks, Doug. I'll be dreaming about that tonight. But we do hope that you find this helpful. We had 10 ideas, maybe a few extra bonuses, and we hope that maybe there's a few that you took away saying, hey, that's maybe something I could take a look at. And again, the goal is the ones that you love, leaving them with a little bit less messy legacy. So we are a little bit over time. I just want to again thank you, Doug, for joining me on the panel. Thank you to UBC Okanagan and Embrace Aging, but most importantly, thank you for giving us your evening to join and just learn a little bit about estate planning. And there are still a few other events out there, so you can go to the website OkanaganembraceAging.com. I believe if you've registered and you've attended, you'll actually get a copy of the recording, as well as some survey feedback. So please do go ahead and share that. Also, we're going to include a link to the Memorial Society of BC. They've got some great resources around checklists and things to help you on your path get organized. I think there's a one-time fee. It's a non-profit organization. And actually, there's a lot of great information and places that you can have a look at. So we'll include that. But again, from Interior Savings Credit Union and on behalf of Okanagan Embrace Aging, thank you very much for joining and have a great night.
Yeah, thank you, Ken. And thank you for everybody that joined and Embrace Aging. Have a good night.
Take care.
Bye now.